did you want us to do this from the podium? Or?
Yes, sir, I do.
This is Patrick McDowell before the court. Mr. McDowell has authorized me to withdraw his previously entered pleas of not guilty and enter pleas of guilty to each count of the information for the reason that he is guilty. This is not a negotiated plea. The terms are that it's an open plea. The penalty phase will be held before a jury for count one. The court will determine the sentences for the remaining counts, and the defendant will be assessed court costs and public defender fee and will receive credit for time served since his arrest. I have reviewed with Mr. McDowell the plea of guilty form. I have signed it. He's prepared to sign it in open court. We have discussed this case thoroughly, Your Honor. The facts of the case and also what the consequences of this plea could be. Mr. McDowell understands that the plea waives any legal arguments that he might have as to the trial phase, but that there still remain arguments that can be made about the penalty phase. Part of the plea also is that we waive pre-sentence investigation due to doing one being penalty.
All right. So signed it. Madam Clerk, when you give an opportunity, please swear the defendant in.
Yes, Your Honor. Raise your right hand. Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I do.
All right, Mr. McDowell, your attorney, you are here in front of this court facing the following charges. They are count one is first degree premeditated murder. That's a capital felony under Florida law. It carries the possibility of only two sentences, either life without parole or death. Count two is a charge of use of a deadly weapon to injure a police canine. That is a third degree felony. It carries up to a maximum of 5 years in prison with a possible sentence. And then counts 3 through 10 consist of 8 counts of aggravated assault on a law enforcement officer. All those are second degree felonies. Each one of those is a second degree felony. Carries up to a maximum of 15 years in prison as a possible sentence on each charge. Are you aware of the charges that have been filed against you, sir?
Yes, sir.
Those are the charges that are contained in the indictment. You understand that?
Yes, sir.
Okay, and you understand the maximum sentences you could receive if found guilty of any one of those charges?
Yes, sir.
All right. With respect to the aggravated assault on a law enforcement officer, each of those charges also carries with it a 3-year minimum mandatory sentence if found guilty of just any one of those single charges. Do you understand that?
Yes, sir.
All right. With respect to all of the charges except for the charge of first degree premeditated murder, if you were found guilty of the other remaining 9 charges, it is my understanding you would have a guideline score on those charges alone of 164.85 months in Florida State Prison. Are you aware of that, sir?
Yes, sir.
You understand the guideline score is most likely the lowest permissible sentence this court can impose if you are found guilty of those 9 charges separate and apart from the premeditated murder charge.
Yes, sir.
And on those 9 charges as well, the maximum you could receive goes all the way up to 125 years in Florida State Prison should you be sentenced consecutive on all those charges. Are you aware of that as well?
Yes, sir.
All right. So it's my understanding from your attorney that you wish to change your pleas of not guilty this morning to all those 10 charges and 2 pleas of guilty. Is that what you want to do?
Yes, sir, it is.
So for the charge of first degree premeditated murder, how do you plead?
Guilty.
To the charge of use of a deadly weapon to injure a police canine, how do you plead?
Guilty.
As to the 8 counts of aggravated assault on a law enforcement officer, how do you plead?
Guilty.
All right, you understand that by entering a plea of guilty to the capital felony charge of first-degree murder, again, there are only two choices that this court can impose as far as a sentence goes. Either life in prison without parole, or again, it could be also result in a death penalty sentence.
Yes, sir.
Okay? Now, have you spoken with your attorney about all of these charges?
Yes, sir.
Have you gone over the state's evidence with him in depth?
Yes, sir, I have.
All right, and have you gone over the potential sentencing ranges and potential sentences you could receive if you plead guilty to all of these charges?
Yes, sir.
And has he answered all of your questions to your satisfaction?
Yes, sir, yes.
Do you have any further questions of your attorney about anything before we proceed forward?
I do not.
Is there any further investigation you feel your attorney needs to do in this case on your behalf that he hasn't already done?
No, sir.
Is there anything else you feel your attorney needs to do on your behalf, at least with respect to the innocence or guilt phase of this case, that he hasn't already done?
No, sir.
All right. Are you satisfied with your attorney's representation in this case up to this point?
Yes, I am, sir.
Okay. If I accept your pleas here today, what will happen is I will pass your case for sentencing on counts 2 through 10 in the sentencing hearing, where again I will consider that sentencing range we already discussed. Okay. With respect to count 1, the first degree premeditated murder count, we will move to a penalty phase in front of a jury. You understand that?
Yes, sir.
Okay, and at that penalty phase, the state will have to present evidence and prove beyond a reasonable doubt the existence of aggravating factors, and there will be evidence that you will be able to put in mitigating factors. And then the jury will then determine whether the state has proven beyond a reasonable doubt those aggravating factors. And if there is at least one aggravating factor that has been proven, then the jury will consider whether or not to vote for whether your sentence should be death or life in prison without parole. That's generally how the process works. Do you understand that?
Yes, sir.
And you've gone over that with Mr. Chipperfield in depth?
I have, sir.
All right. And ultimately, this court will have the ultimate say and determination as to whether or not you will be sentenced to life in prison on count 1, or you will receive the death penalty. If the jury's vote makes you eligible for you to receive the death penalty. Do you understand that?
Yes, sir.
Knowing all that, you still wish to go forward and enter your pleas of guilty to these charges, including the count 1, first degree premeditated murder.
Yes, sir, I do.
All right. Now, has one of the things that, well, let me go over this first of all. Has anyone promised you or guaranteed you any specific sentence to get you to enter your pleas of guilty here today?
No, sir.
Has anyone guaranteed you that you will receive a sentence of life without parole on count 1 if you enter your pleas of guilty here today?
No, sir.
Has your attorney guaranteed you or promised you that you will receive a sentence of life without parole if you enter your pleas of guilty to count 1 today?
No, sir.
All right, you understand that there's no guarantee as to what the sentences will be, except for that they will be within the parameters under the law that we're, for all these counts. You understand that?
Yes, sir.
All right. One other thing I really need to go over with you, because we're in a unique situation, there is, at this time, the Florida legislature is considering changes to how capital punishment works in the state of Florida. There are, right now, it takes a unanimous recommendation from the jury, and there will be a jury of 12 individuals. It takes a unanimous recommendation for death for a defendant to be eligible to receive the death penalty. So in addition to proof of aggravating factors, right now under Florida law, it takes a unanimous jury. You understand that?
Yes, sir.
There are many proposals that are going on in the legislative session that started this week to revise the unanimity requirement. There have been various proposals, and I have no idea where that's going to result. I don't know if there's going to be changes or what those changes might be. All right, your attorney can't guarantee or tell you that, and certainly the state can't tell you or guarantee you what those changes may be. You understand that?
I do, sir.
Okay, some of those changes that they're proposing, and which will eliminate the unanimity requirement, there's also a potential that that could apply to your case. All right, do you understand that?
Yes, sir.
I can't tell you ultimately whether or not any change is going to apply to your case retroactively or not. Your attorney can't, nor can Mr. Khalil at State Attorney's Office. Do you understand that?
Yes, sir.
We just don't know, and it could take years of litigation to determine whether or not a case like yours, if there are changes in the legislation, as to whether they would impact you or not. Do you understand that?
Yes, sir.
And so I wanted to go over this with you because I need to know whether or not, first of all, you know that, and obviously you've talked about this with Mr. Chipfield some.
Yes, sir.
All right, do you have any other questions of Mr. Chipfield or the court about potential changes in legislation and how it might impact your case?
No, sir, I don't have any questions.
Knowing that the legislature might change the way the death penalty works in the state of Florida and may revise the unanimity requirement to require something less than a unanimous jury verdict of 12-0 recommending death, do you still want to enter pleas of guilty to all these charges, including count 1?
Yes, sir, I do.
All right, any questions
No.
so far? All right, so you've gone over the process with your attorney. You've also discussed the possibility of changes. Is that correct?
Yes, sir.
All right, and so, again, one last time, you understand there is no guarantee that you will receive a life sentence without parole if you enter your pleas of guilty this morning.
I understand, sir.
Has anyone threatened you, forced you, or coerced you in any way to enter your pleas of guilty to all 10 of these charges?
No, sir.
All right, have you taken any medications this morning?
No, sir.
Are you under the influence of any alcoholic beverage or any drug at this moment?
No, sir.
All right, and have you received any promises whatsoever from any source, whether it's your attorney, the state, or anyone, to get you to enter your pleas of guilty to these charges?
No, sir.
Before you came before the court, did you receive this written plea form? It's titled Plea of Guilty Without Negotiated Sentence.
Yes, sir, I did.
You can read and write?
Yes, sir.
And how old are you, sir?
37.
What's the last level of education or grade you completed?
Some college.
Some college, you graduated high school?
Yes, sir.
I'm sorry?
Yes, sir.
All right, so you received this form, did you read it?
Yes, sir, I
Did
did.
you go over it with your attorney?
Yes, sir.
Once you read it and went over it with your attorney, did you understand it?
Yes, sir.
And in open court here this morning, did you sign it?
Yes, sir.
Are you entering your pleas of guilty to each and every one of these 10 charges because you believe you're guilty of each and every one of these crimes?
Yes, sir.
If I accept your pleas here today, you waive certain rights that you're guaranteed under the Constitution. Those rights include the right to a trial, the right to a jury trial. And again, the right to a trial and a jury trial, as it will pertain only to your guilt or innocence. You will still have a right to a trial and a jury trial on the penalty phase aspect of count 1, the premeditated murder charge. But you will be waiving your right to a jury trial for any and all other charges, and also guilt or innocence as to count 1. Do you understand that?
Yes, sir.
You also will be waiving your right to an attorney at all critical stages of the case, including the trial on these charges. Now, you still have a right to a trial going forward on the penalty phase of count 1, but you certainly will not necessarily have a right to a jury trial on any issue, a right to an attorney, on anything having to do with the guilt or innocence. You understand that?
Yes, sir.
You still have a right to an attorney going forward for the penalty phase. All right, but you're waiving your right to an attorney with respect to all 9 of these other charges, including at trial. You understand that?
Yes, sir.
Probably got a little convoluted on that. Any questions about, waiving your right to an attorney?
No, sir.
All right? You will be waiving your right to call witnesses to testify for you, at least with respect to all 9 of the charges and the guilt and innocence phase of count 1. You will be waiving your right to cross-examine all state witnesses that testify against you with respect to counts 2 through 10, and also with respect to any issues of guilt or innocence on count 1. You'll be waiving, you'll be waiving, well, you would be waiving your right to remain silent with respect to counts 2 through 10 at least. You would also be waiving your right to require the state to prove your guilt beyond a reasonable doubt with respect to all of these charges. And then if you went to trial on at least counts 2 through 10, and you weren't satisfied with the outcome, you have a right to appeal any and all issues to a higher court, but you're waiving that right as well. Do you understand that?
Yes, sir.
And so you will also be waiving your right to appeal any issues with respect to guilt or innocence.
Could we interrupt for just a minute?
Yes.
He's just getting faint. Can he sit down, Mr.?
That's sure. Do you need to sit down?
Yes.
Do we need to stop the plea colloquy for a few minutes?
If we could do that, thank you.
All right, what I'll do is I'm gonna recess for 5 minutes, so I'll be back.
All right. Thank you, Chief.
everybody have a seat, and Mr. Chipfield, if you wish to come forward. All right. Mr. Chipfield, is your understanding that your client still wants to proceed forward?
Yes, Your Honor, it's a medication issue, he didn't get meds because they brought him from the jail so early this morning.
All right, well, let's talk about that real quickly. Mr. McDowell, obviously you were feeling a little faint or needed to sit down. Are you feeling okay at this point to go forward?
Yes, sir,
Do you
absolutely.
want to go forward?
Yes, sir.
Have you been able to understand all of my questions up to this point?
Yes, sir.
You've been confused, dizzy, or disoriented in any way before you had to sit down?
No, sir.
Okay, is there any questions about the questions that I've asked you up to this point?
No, sir, and I apologize for the interruption.
There's no need to apologize. If you're not well, we can postpone this to a later date. You understand that?
I'm good to go, sir.
You want to go forward?
Yes, sir.
I understand that you take certain medications in the morning, certain medications in the evening. You did not have the morning medications because you had to get up early to travel up here to Nassau County. Is that what's happened?
Yes, sir.
The fact that you did not have that medication, has that in any way affected your ability to concentrate or understand these proceedings up to this point?
No, sir.
And you want to postpone this until you've been able to take those morning medications and let those, obviously have an effect.
No, sir, I'm ready to move forward.
Okay, let's go back to the constitutional rights, because you were distracted, I was distracted, and I want to make sure that you understand this, okay? In this case, as in all criminal cases, you have certain constitutional rights that you're guaranteed, and those are as follows. You have the right to a trial, the right to a jury trial, the right to an attorney at all critical stages of your case, including the trial, the right to call witnesses to testify for you, the right to cross-examine state witnesses that testify against you, the right to remain silent at all times, including the trial, the right to require the state to come to trial and prove your guilt beyond a reasonable doubt. Finally, if you went to trial and you were not satisfied with the result, you have the right to appeal any and all issues to a higher court. You understand you have all those rights?
Yes, sir.
Now, by entering your pleas of guilty to all these charges, with respect to counts 2 through 10, you're waiving each and every one of those rights. Do you understand that?
I do, sir.
With respect to count 1, you are waiving all those rights with respect to any guilt or innocence phase issues, okay? But obviously, you still have a right to an attorney, a right to a jury trial, a right to cross-examine witnesses, a right to call witnesses, present evidence, obviously the right to appeal any and all issues, and the right to require the state to prove the necessary elements beyond a reasonable doubt during the penalty phase, okay? But with respect to the guilt and innocence phase, you've waived all those rights. Do you understand that?
Yes, sir.
Any questions about your constitutional rights and the extent of your waiver of those constitutional rights by entering your pleas of guilty to all of these charges?
No, sir.
By entering your pleas of guilty here today, you're also waiving any rights that you have for your attorney to file any further motions on your behalf that might challenge the evidence as to your innocence or guilt. Do you understand that?
Yes, sir.
Still file all necessary motions concerning, the penalty phase as to count 1, but with respect to innocence or guilt phase issues, or counts 2 through 10, you're waiving your attorney's right to file any other motions on your behalf with respect to those items. Do you understand that?
Yes, sir.
Okay, you're waiving your right to have your attorney challenge the constitutionality of your arrest or any searches or seizures of evidence in this case by entering your pleas of guilty here today. Do you understand that as well?
Yes, sir.
Basically, what's going to be left if I accept your pleas of guilty here today is the penalty phase, the evidentiary portion of the penalty phase, and the jury trial with respect to the penalty phase, and that is it. And there will be no motions or issues that will be considered any further with respect to your innocence or guilt with respect to counts 1 through 10. Do you understand that?
Yes, sir.
All right, any questions about that?
No, sir.
Your attorney will also no longer investigate matters related to your guilt or innocence as to count 1 or counts 2 through 10. Do you understand that?
Yes, sir.
All right, if you enter pleas of guilty to these charges, and you are not a U.S. citizen, you will be deported from this country. Do you understand that?
Yes, sir.
And knowing that, you still wish to enter your pleas of guilty.
Yes, sir.
If in the past you have been convicted of what would be considered a sexually motivated or sexually violent offense or law, and you enter pleas of guilty to these charges, you risk the possibility of sanctions under what's called the Junior Rights Act. And those sanctions can include involuntary civil commitment for an indefinite period of time once you complete whatever term of incarceration that may be imposed in connection with these 10 charges. Do you understand that, sir?
Yes, sir.
Knowing that, do you still wish to enter your pleas of guilty?
Yes, sir.
Is I just aware of any DNA evidence that would exonerate this defendant on any of these charges?
None from the state, Your Honor.
None from the defense.
Is there any DNA evidence at all involved in this case?
There is, Your Honor, there was DNA testing done on a number of pieces of evidence, and it all pointed to the guilt of Mr. McDowell.
Is that your understanding as well, Mr. Chipfield?
It is.
Mr. McDowell, have you discussed this evidence, this DNA evidence with your attorney?
Yes, sir.
All right, at this time, the state wish to proffer a factual basis for all 10 charges?
Yes, Your Honor, the state would be able to prove beyond a reasonable doubt at trial as to count one of the indictment, first-degree murder. On September 23rd, 2021, Deputy Joshua Moyers of the Nassau County Sheriff's Office conducted a traffic stop on a stolen maroon minivan at the intersection of State Road 301 and Sandy Ford Road. The defendant, Patrick McDowell, was the driver of that vehicle. During the traffic stop, Deputy Moyers asked the defendant to exit the vehicle. The defendant suddenly grabbed a stolen firearm he had concealed from Deputy Moyers' sight and shot Deputy Moyers at close range in the face. The defendant then leaned out the driver's window and shot Deputy Moyers 2 additional times in the back as he lay defenseless on the ground. The defendant then fled the scene. Fellow officers found Deputy Moyers in the roadway and attempted life-saving measures. Deputy Moyers was transported to the University of Florida Health in Jacksonville, where he later died of his injuries on September 26, 2021. This would establish a factual basis as to first-degree murder, contrary to violation of Florida Statute 782.04, subsection 1A and 775.0872A3. As to counts 2 through 10 of the indictment, the state would be able to establish the following facts beyond a reasonable doubt. Following the shooting, defendant Patrick McDowell drove a short distance down Sandy Ford Road and he abandoned the stolen vehicle. The defendant fled into nearby property and concealed himself in a wooded area armed with a handgun, the same handgun they used to shoot Deputy Moyers, and a .308 rifle that was also stolen. A group of 8 law enforcement officers, both from the Nassau County Sheriff's Office and the Jacksonville Sheriff's Office, searched the wooded area in an attempt to locate the defendant. The search party utilized JSO Police K-9 and Chaos during the course of that search. At approximately 3 a.m. on September 24th, 2021, K-9 Chaos located the defendant in a wooded area where the defendant had concealed himself. Due to the darkness and the thickness of the brush, law enforcement officers could not see the defendant. The defendant shot K-9 Chaos, causing great bodily harm to Chaos. Then, in fear for their lives and the lives of their fellow officers, the following law enforcement officers returned fire at the defendant. Deputy N. Carter of the Nassau County Sheriff's Office, Deputy A. Cohn of the Nassau County Sheriff's Office, Deputy D. Barnes of the Nassau County Sheriff's Office, Officer D. D. Cullen of the Jacksonville Sheriff's Office, Officer M. A. Zona of the Jacksonville Sheriff's Office, Officer J. Holcomb of the Jacksonville Sheriff's Office, Officer J. S. Mason of the Jacksonville Sheriff's Office, and Officer C. C. Hart of the Jacksonville Sheriff's Office. The defendant fired an additional shot to place the officers in fear and to effectuate his escape. Despite being struck by police gunfire, the defendant then evaded law enforcement until the date of his arrest on September 28, 2021. The preceding factual basis establishes that the defendant committed the crimes of injuring or killing a police canine and 8 counts of aggravated assault of a law enforcement officer in violations of Florida statutes 843.19, subsection 2, 784.021, and 784.07, subsection 2C.
Any objection or exception to the factual proffer, Mr. Chipfield?
No, Your Honor.
Mr. McDowell, you've heard the state outline the evidence they're prepared to present in support of each and every one of these 10 charges. Do you accept the state's factual proffer?
Yes, sir.
Based upon the proffer from the state, defendant's acceptance and no objection to it thereto, court finds there is a factual basis for each and every one of these charges. All right, sir, I just want to go over everything one more time, just in summary, to make sure you're aware of what you're doing here today, all right? You understand you have entered pleas of guilty to all 10 of these charges.
Yes, sir.
Okay, do you understand that included in those 10 charges is a charge of first-degree premeditated murder, which has only 2 options for a sentence, and that is number 1, life without parole, or 2, the death penalty.
Yes, sir.
Okay, you understand that your case, if I accept your pleas here today, will be passed for a sentencing hearing on counts 2 through 10, all right, where I will consider a sentence within the legally permissible sentencing range that we've already discussed. However, with respect to count 1, the charge of premeditated murder, your case will be passed for a penalty phase trial in front of a jury of 12 individuals who will determine whether or not the sentence should be life without parole or at least a recommendation of the imposition of the death penalty. Do you understand that as well?
Yes, sir.
What will happen is, at least under current legislation, under current Florida law, is that that penalty phase, the state will have the burden of proving at least one aggravating factor beyond the exclusion of every reasonable doubt. You'll you'll certainly have the opportunity to present all mitigating evidence to the jury. The jury will, if the jury does find that at least one aggravating factor has been proven beyond a reasonable doubt, then they will be asked to balance the aggravating factors with the mitigating factors to vote on a recommendation as to whether or not the sentence should be life or without parole, or the court should impose the death penalty. At this time, it requires a 12-0 recommendation for death for the court to then be able to impose the death penalty, and it is then up to the court at that point to make a final decision. You understand that generally to be the process,
Yes, sir.
and you discussed this with Mr. Chipperfield.
Yes, sir.
You also understand that the legislature right now is considering changing that process that we've generally discussed to eliminate the unanimity requirement of the recommendation from the jury.
Yes, sir.
And you understand that it happens, and that is changed, that could impact your case.
Yes,
You
sir.
understand that?
Yes, sir.
Knowing that, you still wish to enter your pleas of guilty to all these charges, including the charge of first-degree premeditated murder.
Yes, sir.
All right, you understand no one can guarantee you, not your attorney, not the state, or anyone for that matter, can guarantee you that you will receive a sentence of life without parole if you plead guilty today to all these charges.
I understand, sir.
All right? Now, do you have any further questions of your attorney before we proceed forward?
No, sir.
All right, counsel, is there anything else you feel that this court needs to address with Mr. McDowell before proceeding further?
Nothing from the state, Your Honor.
No from the defense.
All right, at this time, the court finds that the pleas of guilty to all 10 charges have been given freely and voluntarily with a full understanding of the nature and consequences of the pleas. The court accepts the defendant's pleas at this time. We'll pass this case for further proceedings. Right now, the trial is set for September, and we'll just leave that in place for now. We talked about another date, sort of to get a status, and I think it was the 18th, I think, was it May 18th, I believe?
It was, Your Honor.
So we'll strike the March pretrial and come back May 18th, regular docket during the morning on that day. Is there, just at this point, can you give me a brief status as to where we are on issues that involve the penalty phase?
Your Honor, we've talked about taking 3 depositions that involve penalty phase information, and we continue to work on mitigation, trying to reach people.
And Your Honor, the state has retained experts and has been conducting an extensive background investigation on Mr. McDowell in anticipation of the mitigation that we expect to be presented by the defense. However, until we receive the formal listing of that mitigation, we can't really move forward any further than we already have.
All right. So with that, if there's nothing else, that will conclude, the plea hearing. And we'll see everyone back here on May 18th.
If you're
Thank you, sir.
Thank you.